Good morning, everybody, and welcome to the latest webinar for school leaders from the Mason, Hayes Curran education team. Today's webinar is entitled Limiting Your Liability, Data Protection and Note-Taking. My name is Ian O'Herlihy. For those of you who haven't met me before, I am head of the education unit in MHC, and I'd like firstly to start by introducing my colleagues this morning, David Ruddy, Catherine Kelly, and Edel Kennedy. And I'd also like to welcome in a particular way and say a big thank you to our partners on today's webinar, NAPD, and in particular, Paul Crone, who's Director of NAPD, and Paul Byrne, who's Deputy Director. So before we kick off, I'd also like to just acknowledge the assistance we've received in putting together today's webinar from the JMB, in particular Cyril Drury in there, who's their data officer, particularly around the issues of data retention and data schedules, and more about that in a couple of minutes. Now, a lot of you principals, deputies, board chairs will have been invited to data protection seminars, webinars, and things like that. And today's webinar is really born out of a kind of a number of requests or comments that have been given to us by principals, deputies, that this issue of compliance with data protection and GDPR is a real challenge. And some people have described it as a kind of a mountain to climb. One person even called it a monster, which was a bit extreme. So what I really want to say by way of intro is we're not even attempting to cover all data protection issues, all GDPR issues today. Instead, we're just picking out a few what we consider hot topics from our engagement with schools and principals, and maybe to look at some sort of easy wins and takeaways, maybe to try to support you so that you can feel you've done something, gone some little step on the road to compliance with data protection and GDPR. Paul.
Thank you, Ian. I'd like to welcome everybody here to this webinar, and we're delighted in NAPD to be partnering with Mason, Hayes and Curran. Mason, Hayes and Curran are leaders in education law in Ireland, and they bring with them a wealth of knowledge and experience to you here today to give you some information that will help you in the job that you're in. I suppose as school leaders, when we applied for the job, our passion being principal, deputy principal, or even middle leaders, were teachers. And our passion is for students, our passion is for learning, our passion is for leading learning. And that's the area that we want to work on as part of our core purpose. However, when you arrive into the job, you realize that there are a whole myriad of other tasks that demand your time, that take your time. And processing data, managing data, and everything that involves with the GDPR regulations and the legal implications and the potential consequences of a breach or making a wrong decision or putting your foot wrong are huge. And it can be a cause of significant stress for leaders in schools. And we've been hearing that as NAPD, and that is the reason why we've partnered with Mason, Hayes and Curran to bring this to you. And I suppose by way of an example, my own situation, I'm foot of a witness summons to the Criminal Court of Justice within the next 2 weeks from my time when I was principal in Old Bawn Community School for a criminal event that happened on grounds that were owned by the school. And the CCTV and my role as data controller, data processor, how we store the data, what we've done and how we use it and all of that. And this will be my third time up in front of a judge and jury being questioned by the prosecution and cross-examined by the defence. And things like that can be very stressful for school leaders. particularly maybe if you're not sure what you're supposed to do or how you're supposed to do things. And that's the purpose of today, to give you the information so that you have a bit of confidence and are able to make good decisions. And at least if you don't know the answer, you will know where to find the answer so that you can protect yourself and reduce your stress levels and reduce the pressure that you are under. Yes, we do plan for hope for the best, but the reality is that issues around freedom of information, data request will end up at your door. So it's important that you have the information at your fingertips, and that's the purpose here today. We will be continuing to support school leaders in this area, and the purpose really here is prevention is better than the cure, and we hope that you get a lot out of it and enjoy today. So thank you very much, and I'm going to hand back now to David.
Thank you, Paul, and good morning, everyone. I suppose the starting point for today is GDPR, and this regulation was brought in almost 3.5 years ago. It's hard to believe now. And simultaneously, our own national government brought in the Data Protection Act of 2018. Prior to that, we had the Data Protection Act of 1988. So this was described to me when it was introduced in 2018 by somebody who said this is a bit like the renewal of one's marriage vows. So I think what they really meant by this was to say, well, look, we've had to reconsider where we were at and how we could improve. So consent very much is at the basis of this. And my colleagues are going to talk about that in more detail, and particularly the enhanced role of the student as we see it. So what are the GDPR principles? And this for me is certainly my Bible. And I think no matter what you're confronted with, if you can go back to these principles, you'll probably find the answers there. I'm not going to go through them this morning, but you have to ask yourself, why do we have information? Now, you have a legitimate reason as a school to collect information at enrollment stage, particularly if students have special education needs. And maybe also as you go along, there may be disciplinary issues and you have to gather information. This is on the pupils, and then you have information on staff. And I suppose the big question, and this was alluded to by Ian at the very beginning, is the question of retention. Do we have to hold on to everything? And if we do have to hold on to some things like child protection files, that's one thing, but there are a lot of other things I feel we're holding on to that we really have no need for, but we'll discuss that later on. And just to say then, what is personal data? And it's very broadly defined, but if you can be identified, a parent can be identified, or indeed a pupil identified on records we have, well then they're entitled to information about themselves or their son or daughter. So we will look at that in detail also. So we're going to start at the basics, and I'm going to call Ian back here to talk about the key actors in all of this. Over to you, Ian.
Thanks, David. Well, I mean, the first thing just to establish, and I think most of the listeners here on this webinar will know this. I mean, who is the data controller? And let's keep it simple. The data controller in your school is the board of management, and that applies even, for example, if you're an ETB school. It's the data controller in your school is not the ETB. It's the board of management of your school. We're actually in a big dispute at the moment on behalf of the school with the data controller, because one particular party is pursuing individual members of a board of management who would have got, she says, personal data relating to her on their home or work computers, because it would have been sent out, there was a particular dispute by the school to the board members for information purposes. Our position is that data is not, controlled by the individual board members. It's controlled by the board of management, and the board of management is data controller. So there can be disputes about that. Who's a processor? Well, maybe just talk about what processing is. Processing is just basically dealing with personal data. That's the easiest word. Storing, collecting, retrieving, using, destroying, whatever it is. So processing, for processing, read, using, or dealing with processing. And then there's an issue about, you know, what rights has a data subject? Now, there's a whole range of rights a data subject, but I just want to mention a couple of them that are relevant to schools. A data subject, a parent, a student, a third party. If the school holds personal data, David looked at the definition on any of these people, it has a right. That person has a right to be informed of what data you hold. They have a right to access to data. Now, you'll be familiar with, some of you familiar with data access requests. So they have a right to access to data, get a copy of it, of data that you hold. And they've other rights like rectification and erasure. Erasure is a big hot topic, not necessarily for schools, but you'd be familiar with the kind of right to be forgotten and these sort of things. But the big right is access to school data.
Ian, can I ask you a question there in relation to agreements with processes? So take, for example, the school photographer comes in, takes photographs of lots of children, has their names, etc. Author be to an agreement between the school and the photographer.
Yeah, if personal data, and what you just referenced there, photographs of children are clearly personal data. If personal data of the school is being used, gathered, or whatever, processed, we would call, by a third party, like a photographer or any other third party, there really needs to be some sort of a data processing agreement between the school and that third party, because otherwise, if things go left field and personal data, for example, gets into somebody's hands, shouldn't get it, and there isn't an agreement in place, the school will be criticized, heavily criticized. So there should be an agreement, David.
Thanks, Ian. And now we're going to look at the types of requests. The education team on a daily basis are dealing with requests, and that would you like to go through the types of requests?
Yeah, I mean, there is a constant stream of queries about requests for personal data, and it ranges from things like historical data, maybe enrollment data going back many years. There can be requests for historical data relating to historical complaints against a school or school personnel, current requests for data, often from either a member of staff or a parent, and often in contentious situations. So we want to say that. CCTV requests, I'm not going to deal with those because they're coming up shortly and separately. Requests for extracts from Board of Management meeting notes and minutes, and digital requests. And oftentimes, like records of schools, some of the ones I've mentioned, will include a personal data relating to some individual, and also personal data relating to other individuals. And that's where we get into what we call redaction, because it's very important that in giving somebody access to their data, you don't inadvertently give them access to somebody else's data, because that would be a data breach.
Thank you, Ian, and we'll come back to you in a moment. I'm now going to call on Edel. Good morning, Edel. How are you?
Good morning, David. Very well, thanks.
Edel, we're going to look at a particular scenario, and indeed you have countless scenarios that real-life cases that you deal with on a daily basis. But if you'd like to take us through this, please, it would be great.
Yeah, this is, I suppose, just I thought it useful to jot down this type of scenario just to get give you some insight as to the type of cases that we have. So in this situation, Tom was married to Mary, but is now seeking a divorce. He has sent a data access request to the school for his son and for his daughter, aged 13 and 15. Equally, he is seeking data for his older children who completed their leaving certificate a few years ago. And the question then being posed, what data is Tom entitled to? So I suppose the first question that I would recommend a principal who's in receipt of a request of this nature ask themselves is, are you satisfied as to the status and the identity of the person who's making the request? And I think just in our own discussions in preparation for today, you know, Paul Byrne was mentioned and highlighted the importance of that in terms of, you know, kind of first steps. So, you know, to satisfy yourself that Tom is who he says he is, and that you're satisfied that he was in fact married to Mary, and as such he is a legal guardian of the children, and then following on from that, that he can make a request and be entitled to documentation. So that's question number one, if you like. Question number two to be asked is, well, we've established the fact that he is a legal guardian, then what are we obliged to provide him with? And what's relevant here is the age of the students, age 13 and 15. The position of the DPC, the Data Protection Commissioner's Office, is very much that, you know, a child of age 15 or teenage years who is in this particular situation, and if there is some contention as between the parents, should be consulted or informed of the fact that this request has been made by his father to seek his views. And it may well be the case that I'm taking it that the son here, who's 15, that the son doesn't wish for his father to be provided with the documentation. Like, that's something to be taken into consideration, because it is increasingly the case that the DPC would be of the view that a teenager of that age should be in a position to object or refuse that documentation being provided to his father Tom in this instance. And that kind of mirrors advice that we would frequently provide schools on what is practically an annual question at this stage for our department. That is the one of the junior certificate results that are issued, and the parent of a child, parents are separated. Dad, let's say in this scenario, rings the school and looks for the junior certificate results. So in that situation, what we would do is we would talk to the son, the 15-year-old son, and ask him if he was agreeable to those results being disclosed to his father. And in that situation, if he didn't consent or refused that information or those results being provided to the father, that view would have to be respected. Moving to the request for the data seeking in respect of the older children here who completed their leaving certificate a few years ago, the position would very much be that those children should be, or those adults now, should be consulted with, or at the very least, I think you'd be writing back to the father in that situation saying that if those children are looking to put in a data access request, that they'll have to do so in their own respect. That is, that they will write independently to the school, either A, look consenting to their father being provided with a copy of their records, or B, asking that the documentation be released to themselves. I'm thinking of a situation in particular whereby we had I'm advising a school in the last couple of months who had a letter of complaint come in from a parent about the treatment at the hands of a teacher. Now, this is supposed to have happened actually when the child was in primary school. And in that situation, my first response to the principal was to write back to the mother and say that as the child was now, I think would have been, or the child as she was then, but she would now be an adult, I think age 20, and that her consent would be sought for a response or for compliance in respect of a data access request. So that's typically the type of questions and the position that we would take in dealing with a scenario of this nature, David.
So Edel, you're very reflective of the views of the DPC, and that is seeking the consent in some circumstances of students in schools, depending on their age and maturity on that.
Yes, and I mean, look, the issue of consent and the DPC's position on consent, I mean, Ian can speak more to that, but you know, for schools, the issue of consent is, you know, guardians or parents, for the most part, give consent on behalf of children and teenagers. But in specific instances like this, I think you would certainly be looking to the children for their consent when a request like this would be made and when they're of that age.
Thanks for that, Edel.
David, I suppose just to make a comment, I agree completely with what Edel has said there. I mean, at a kind of a general level, the DPC has come out and said that they really prefer data controllers to have some other basis other than consent for processing or giving out personal data. But to be quite honest, and this is where I would agree completely with Edel, I mean, in the school situation, we don't have the facility to be coming up with other legal base aids other than consent. So I would just say it really, we have to operate with consent. Otherwise, we just couldn't, we couldn't operate at all in a school.
Consent is king, Ian, you're saying?
Well, it has to be in schools because we don't have the facility that social media companies and that kind of things would have.
Okay, thanks for that. We're going to move on to another scenario. Good morning, or it would have been early good afternoon. Catherine, how are you?
Good morning.
This is in relation to a disciplinary incident and CCTV. I should point out at the outset that you have been involved in a number of what I would say high profile cases involving expulsions, and that unfortunately, and in the circuit court and indeed in the High Court. So you're no stranger to this sort of scenario, and I'll hand it to you now.
I have been involved in one in particular in relation to CCTV in a fight that occurred in the school, and it was not where a student was seriously injured, but we put it in this scenario, and the principal is proposing to discipline another student based on CCTV footage evidence. The parents of boy X claim that this footage is inadmissible, as CCTV should only be used for the perimeter of the school. So I think what we need to always look at is the signage in relation to the CCTV. I mean, obviously there should be signs up stating that the school is using CCTV and also stating the purpose for the CCTV. That's really, really important. You should have a policy in place which sets out the purpose of it. And it should be linked to the code of behaviour. And that was very important in this case because we could use the footage that we had to prove what had happened. And it was referenced in the code of behaviour in relation to the health and safety issues that could arise in the school. Also, very, very important that the students know that it is in place and that it is linked to the code of behaviour, and that the staff know. So you can't just put in place CCTV and nobody knows about it. There's no signage up. It's not linked to any of the policies in the school. It's very, very important that that happens. And if we go on to the next slide, which also deals with that, we're often asked and we're requested by parents for copies of CCTV footage. And this happens a lot at the moment now. The cost of it is, it can be very onerous on a school. We would have to say, that the majority of the time we would say no, that it's not appropriate, it's not reasonable for the parents to be provided with a copy of it. Also, we need to protect the rights of the other individuals involved. So, if we want to pixelate it, that's going to be a huge cost to the school. It may be that you could print out the stills and that would be sufficient, and we could maybe black out the other individuals involved. I did have a case where we did that. We had a Section 29 appeal and it involved an assault of a student in a school. And fortunately, we had a member of the board who was very adept and worked in IT, who spent hours and hours and hours going through the footage and pixelated out all of the other individuals involved so that we had protected their rights. But, that was very much in that case. In other cases, we've been asked to provide and pixelate it, and I've said no on the basis of the huge cost that would be incurred. It's different if we're involved in high court litigation and we're asked for it. We would be obliged to furnish that as part of, say, a discovery process. But from the day-to-day running of the school, I would very much push back on being asked for copies of CCTV.
So, Catherine, a big takeaway from what you have said, and indeed your experience of representing schools where expulsions have been proposed by the board, and that is referencing the use of CCTV cameras in the code of behaviour.
Absolutely.
There. So I'd say to our members, our listeners this morning to very much take that on board. I think that's a great piece of advice. Thanks, and I'll come back to you.
I might jump in just to add to that, David.
Sorry, yes, Edel. Sorry.
Just as Catherine was speaking, I was thinking of a current case that we were advising on, and it was a disciplinary involving a serious attack on a student, and it was footage. It was of a rugby game and footage that was taken for training purposes of that game. And in that situation, the issue and reliance on the footage, the video footage rather than CCTV, it kind of came to the forefront. And again, you know, the importance, as Catherine was saying, of the code of behaviour and a link up between the use of footage or CCTV footage in the code of behaviour and the school having its own data protection policy, which would again perhaps make reference to it, just the importance of that. And, you know, the possibility of a parent or the student objecting to any video footage being relied on in any disciplinary process in the absence of that code of behaviour. And then significantly, you know, the issue, this is again going to the issue of knowledge and consent in terms of the code of behaviour, but quite frequently we see schools who update their codes of behaviour, which is great, it should be revised, it's a living document, but that they do so in the absence of having any consultation process with the students or with the parents of students. And then you could argue that if it's revised to include, let's say, a clause about CCTV footage or about video footage, unless there has been that period of consultation, you could say that it hasn't been agreed to again, you know, by the students or by their parents. So just to be careful on that front.
Thanks for that, Edel, and indeed Catherine there. And as I say, while I have you, Edel, can I just put a scenario to you there? We'll put you just, we might do a career swap just for a moment for you here. You're principal of a school and you receive a phone call from the Department of Social Protection. A charming young man on the phone is phoning to see, have you got the following students enrolled in the school? He's, you know, he's in the fraud section.
He's in the fraud section calling down from Letterkenny, and you want to be seen to be obliging, and it's another body of the state, and you're satisfied that, you know, we're all in this together, supporting each other. Yes,
you have it.
Look, this is one that obviously there has to be a level of caution. I mean, we all want to cooperate with somebody who, on the face of it, you know, is looking for assistance from you, cooperation between, you know, the school and the department or whoever it is, let's say from this list that's making contact with you. But the issue is that there has to be a level of, similar to a request being submitted from the parent in the scenario that I gave earlier, we have to have verification, number one, as to who it is that they are we satisfied that they are who they say they are? And the best way of going about that is to have some written confirmation provided by the individual in question, so that if you're caught on the hop, you know, on a phone call, or I've certainly had situations whereby the Gardaí have arrived down to a school looking to collect files, or you might have gotten a phone call saying, this is Garda so-and-so, I'm going to drop down to you at X o'clock, you know, to pick up a file relating to a student. That in that situation, as it stands, dealing with that issue with the Gardaí, for instance, it's necessary for a legal obligation to be cited or relied on for the provision of documentation by the school. So it's not enough to simply have a bare request. And similarly, it's not enough to cite GDPR as a reason for providing documentation or information to any of these bodies. I've certainly come across instances in the last couple of months whereby we've had, you know, correspondence from Inspector Kennedy looking for information relating to XYZ, and is citing GDPR as the basis for the school giving the documentation to him, and that he will drop down personally to collect it. Thank you very much indeed.
Edel, your takeaway here then really is you want a legal basis and you want it in writing. Would that be?
It has to be, and it's not sufficient to say that it's GDPR is the reason, or that isn't the legal basis on which a request like that can be made, and just to be conscious of that.
Thanks very much for that insight. And I'm going to move on next to teacher's notes. Ian, as a lawyer, you enjoy legal professional privilege in relation to your notes. In relation to teachers, is it a case of what we have, we hold? So, you're on silent there. Thank you.
Sorry, David. Like a lot of answers, it depends. I mean, the issue here is, you know, what constitutes school records and what constitutes personal records. And like so many answers to questions, the two ends of a spectrum are fairly clear, but it can get a little bit gray towards the middle. Now, if I just turn to the bottom bullet point there, there is in GDPR what's known as the household exemption. Article 2.2 of the GDPR says that, you know, GDPR does not apply to processing data, and the wording is used in the course of purely personal or household activity. That's the wording used. And I kind of laughed when I read that, just getting ready for this, because I said to myself, thank God that exists, because my wife and I have a WhatsApp link, and we exchange comments about our children, and I'm really glad that our children don't always have access to that. So that's a household exemption. But just to say that this is quite a narrowly defined exemption, and the wording is used is the exemption applies where there is no connection to any professional or commercial activity. So just because you put something down as personal doesn't necessarily get you home. Just a few easy answers. You know, if notes, records, whatever are kept on a school desktop, laptop, iPad, or a school device, the starting point is that's a school record. Or if they're in an old style hard copy filing cabinet, or in what's referred to as a retrievable format, that's a school record. But there are some times when, you know, genuinely teachers keep a personal diary of events, personal events and stuff. And that's where it can get a little gray. You know, the general starting point is school records are accessible by parents, full stop.
Okay, thanks for that. And that brings us neatly to the next thing of the next point of communications with parents. Now, this is really important, particularly if there's a contentious issue. So what's your take on that?
Yeah, well, I mean, the first question that crops up here is, you know, when do I need to keep a note of a meeting? And nobody can give you a simple answer to that, because it's a judgment call to be made. I mean, clearly principals aren't going around noting down every single discussion that they have, but principals, particularly where they have a bit of experience and judgment, they're really good at spotting trouble or potential trouble, you know, potential contention with either a parent or indeed a student, or with a member of staff or whatever. So like when your judgment tells you this is an important discussion, this is an important meeting, I need to keep a record of it, you should keep a record of it. And if you're really concerned about you know, a record being kept, it is a fantastic thing to follow it up, sometimes to a member of staff, but more likely to a parent or whatever, with an email, just saying, you know, further to our meeting today, we discussed X and Y, and it was decided A, B, and C. Because we have found on the team that it is amazing how two people can come out of a meeting, maybe a principal and a parent with completely different understandings and recollections of what was actually discussed. And an email like that, you know, only being sent in exceptional circumstances, but an email like that is a huge benefit and a huge protection because it puts a record of what was actually decided.
Ian, the next thing, of course, is note taking, and lawyers love to have notes and documentation on that. And equally, principals demand of teachers to keep notes in relation to supervision, bullying issues, etc. You have a few hints for us here, or tips from your experience.
Yeah, well, it's only just, there's a number of cases where I remember reading notes that we were required to give over, and there would have been comments or language in it that you would prefer not to have seen. You know, there's a couple of comments there. You kind of be careful. You have to keep notes and records on the basis that they will end up being accessed or examined by the person to whom the notes apply. So you have to do that. So you have to kind of, that's really a starting point. And I just said, avoid throwaway gratuitous comments. The kind of ones that come up in my mind are, you know, a principal writing down, you know, in his view, there's no proper parenting going on in that household. Well, you know, do you know that? Or can you make that comment? You may feel that's the view that you have. And by the way, it may well be right, but can you actually stand over that comment? One that you've heard me say before, a principal wrote down, you know, about a student who'd gone crazy repeatedly. And he said, this didn't surprise me. I thought her mother 30 years ago and she was the same. You know, not a great comment to see written down. You know, descriptions of a child coming from a dysfunctional family. Well, do you know that? You know, now, having said what I've just said, I don't want for one moment to suggest that you don't put down, you know, criticism of people's behavior, be it at a meeting or a student's behavior or a parent's behavior or a member of staff, if they have behaved or conducted themselves, you know, objectionably, you record it and you put that down. Factual. You're entitled to have a view and you're entitled to record it, but just be aware of the gratuitous comment.
Thanks for that, Ian, and we'll come back to you in a couple of moments. Now we move on to you, our participants. We want to ask your opinion in relation to a few questions. And I suppose the backdrop to this is retention schedules. Our management bodies came up with suggested retention schedules, guidelines for schools, which I think schools found very helpful. But post GDPR, they're revisiting these retention schedules, and we're happy to be part of the consultation in relation to this in MHC. And Paul Byrne, Deputy Director of NAPD, is going to pose the questions there, and I'll be looking for his reaction to the answers to maybe with Paul Crone also, and from my colleagues in MHC. So Paul, I'll hand over to you.
Thank you, David. I suppose the first question in the poll is, how long do you think you should retain emails for? And you've got 4 options there: 6 months, 1 year, 2 years, and 5 years. So if you take a few seconds just to click one of those choices, and then we should be able to bring up the results fairly quickly. I suppose the purpose here is to get an idea of your perception at the moment of how long you think that this data should be retained for. So if we could bring up the results now, if they're in, please.
So
the majority, well, 52% believe it should be for 5 years. Now I know that David and Ian will probably speak to this once we have the next questions done. So we might move on to the next one in the poll, please.
okay.
So we should have a second poll coming up. So in the second one, we are looking to see how long should we retain records of school trips and permission slips. And your options there, 6 months, a year, 2 years, or never destroy. And secondly, how long should we retain SEN files and psychological reports? You have the same 4 options there, 6 months, 1 year, 2 years, and never destroy. Now, we should be able to bring up
just while people are voting there, I mean, we have been doing a lot of discussions on the team in relation to this issue of retention periods, and it's you know, we don't want to say it's black and white. We don't want to say it has to be X or it has to be Y, but the real challenge is that the DPC, if there's a dispute, will challenge and will say, Mr. School, Mr. Board of Management, Mr. Principal, Mrs. Principal, what is your lawful purpose for retaining that record for the period for which you're retaining it? And you have to come up with an answer. So that's kind of what's behind some of these questions.
Ian, just while we're waiting for that result to come in, I will say the one on emails there, I've just jotted down a figure. 52% of our participants feel we should hold on to the emails for 5 years or that. And, you know, I suppose are you surprised with that? Or is Paul?
Well, I am a little bit, but I also would challenge people as to why are you holding on? Because emails can be about everything and anything. So, you know, a member of staff sends in an email about something minor. Well, why would you not delete that fairly readily? You know, whereas there could be an email from a solicitor threatening a claim against a school. That's a different kettle of fish. So really, you know, it depends, and we're not going to sort this out on today's webinar. But what we're really trying to do is to be provocative and say, you know, why are you retaining the emails for 5 years? You have to have a lawful purpose.
I just come in there very briefly, and I mean, I would have used this when I was in the school about using your teacher's magic eye, using your leader's magic eye. If there's something that you know is potentially contentious, well then I would have always pushed it off into a folder on the side and retained that. But there is, and I know a principal can get anything from 40 to 120, depending if you're in an ETB, emails a day. And it can, your computer will collapse with the amount of emails. So it is something that needs to be thought about and probably needs further discussion.
Will we look at the results of the second one there?
Yeah.
Yes. Thank you, Sinead. Sinead Marr is, thank you, Sinead. So this is Paul, the trips and permission slips there. And
there's a huge variety in opinions there.
And I mean, the big question really is, if the trip goes off without, I mean, you could have, in any week, you could have 8 or 10 trips. You probably need another school to store the permission slips in before too long. If the trip goes off without a hitch, there's potential, I would say anyway, and you may correct me if I'm wrong, potentially no need to hang on to the permission slip. It's if there's an accident or if there's an issue or whatever during the trip that you may need to go back to it. But if the trip is successful without issue, or if you could constantly do that, you continuously do that, and no student is allowed go on a trip without a permission slip, I wonder, is there any need to retain them? You may correct me on that.
No, I would be inclined to agree with that, Paul, but this is something that we will bring out at a later date, just, you know, be provocative, but I would agree with what you've just said.
Just in relation to foreign trips, when you're getting a permission slip there, you're getting permission to bring the child for medical assistance, probably overseas. Those are one of the ones that I would have held on to in the event that some child had an accident, that at least you have the permission to cover the teachers who brought the child for the medical assistance, and also any report that came from the hospital as well, we would have held on to.
That sounds very prudent.
Now we can scroll down to the bottom one.
Yes, yes, and we've done that. We're down at the very final, Paul. So the result there, 89% never destroy. Do you feel that's a reasonable?
I think that would be a prudent play, to be fair, because you never know when something like that is going to crop back up again.
Right, right.
And that might be reasonable, and that's one we're going to take on board as well.
So a big thank you for everyone who participated in this, and certainly it's been an eye-opener and an interesting exercise. Thanks to Paul Byrne there. We'll just move on to the next piece then. Catherine, we're back to you there in relation to what is inevitable will happen. Probably happens a lot of the time and we don't even know, but when it arrives at you, generally is quite serious. But I'll hand it over to you. Thanks.
Yeah, we get asked all the time about various breaches that have occurred. Most of them are minor, to be honest with you. And, you know, we would always advise that you take advice anyway to see whether or not you should make a report to the DPC. As you'd see there, it's in relation to a breach which presents a risk to data subjects. Controllers must notify the DPC without undue delay and within 72 hours. So the 72 hours there is key. I've had a number of them recently, and you know, a few of them have been serious. A lot of them have been very minor. We get sometimes very aggressive letters in from parents, you know, alleging breaches, and I always say to the principals, well, let's get ahead of that and let's make a report to the DPC and get advice on that. And usually the advice is from the DPC that it's not, you know, it's not a serious breach, it's only a minor issue, and the school then deals with it. I have had serious breaches. For example, we had a principal that installed CCTV herself in the school, no approval from the Board of Management. Not sure what the purpose of it was, because we could never get to the bottom of it, and it definitely wasn't set out in any CCTV policy. So there was a lot of footage there. It was a serious breach, and that was reported to the DPC and dealt with by the DPC. It was also included in a stage 4 process against that principal in relation to misconduct, because obviously that was something that had to be taken very, very seriously by the board. Also, Ian has been involved in one where the Medmark report in relation to a teacher was sent out to everyone. Huge mistake there, serious breach, and that was reported to the DPC and dealt with. So the majority of the time, it's not something that is a serious breach. For example, only last week, we were asked to get involved in relation to a parent who was threatening legal proceedings against the school because of its COVID policy in relation to mask wearing and, you know, its COVID response plan. We responded on behalf of the school to that parent, and she has now said that that was a data breach, that the school shouldn't have provided us with her email address, which clearly the school had done for the purposes of getting legal advice. So there's no breach there. So those are a few of the things that we've encountered only in the last month or two.
So Catherine, the default position there is, if you're not sure, I mean, as you say, straight away, you'll know whether it is a serious breach,
yeah,
or not. But if you're not sure, your default position is get in touch with the GPC. And
well, and as well as that, you can also take advice from the various patron associations, like, you know, management bodies like the JMB. They give excellent advice in relation to GDPR, and also ACCS, ETB. Whoever's your management association, just get into contact with them and they will give you great advice on it.
Right. Okay. Thanks very much for that. I'm going to come back then to Ian and Paul to do a wrap up. So thank you.
Thanks, David. I just I suppose a few takeaways, one sentence takeaways. Obviously, we've spoken about CCTV. You know, have you got signage, proper signage, that states that the CCTV is in place, but also the purpose of it? And we would often recommend it at least includes health and safety. Have you a policy which covers your CCTV, and do you cross-reference that in your code of behavior? All just things to bear in mind. Retention of data. You need a lawful purpose. You need to be able to explain why you're retaining the different categories of data. Consent. Just maybe it might be a surprise to some principals, just what Edel was talking about earlier on. Don't forget, if it's student data, don't forget there's a student there, and that student may well have the maturity to decide whether his or her data should be given to somebody who's requesting it. And lastly, meetings. You know, meetings, note-taking. And we would really strongly suggest that this is something that the principals should discuss with their staff, because, you know, staff will feel supported if you share maybe a bit of the conventional wisdom with them in terms of keeping notes and what might be accessible or not. So just before I finish up, and I'm going to hand over to Paul Crone in a moment, just to remind the people who are on today's webinar, you will get from Mason Hayes a questionnaire after this webinar if you have joined us, with questions basically asking how we're doing. And this is really helpful to us because it keeps us on our toes, keeps our pencil sharp. So if you can please take a few minutes just to fill that out, because it's a great help to us in terms of future webinars. Paul.
Thank you very much, Ian. And as I'm finishing up, I just want to thank Ian, David, Catherine and Edel for their work in preparing for this. It's taken a huge amount of work and effort, and thanks to Paul Byrne also. This is an area that sometimes, I know when I was on the ground in a school, sometimes you felt when you get information, you kind of are really a bit more confused, because every scenario and situation has extenuating circumstances. There's always something different. Somebody else has an opinion. Somebody else throws something that's different in your situation. But the key to remember is that the information that you have here today is to inform you that you at least know where to get the information, that something must be done, and that you can go and find that out. And hopefully that prevention will prevent you from having to engage the services of Mason, Hayes and Curran. I'm doing them out of business now as I speak here. But that's what helps you to, suppose, sleep soundly and be able to get back and focus on what NAPD are continually calling your core business. Your core business is your leading learning. So a huge thank you to Mason, Hayes, Curran. Thank you to everybody who has taken time out of your busy schedules. You will be able to get a copy of the recording of this webinar to watch on your Saturday night when you are relaxing with your glass of wine. But the whole point of it is to give you the confidence to go forward, do your job, create the atmosphere and the learning environment in your school without the fear of these regulations coming up and biting you. And we hope that you have got that out of today. So thank you very much to everyone, and I wish you an enjoyable and successful rest of your Thursday. Thank you.